Hello, my name is Nick Clark, and I'm an associate attorney here at the East Carolina Law Group. Today, I'm going to talk to you about civil contempt. Now, you've probably seen in the movies where a judge throws someone in jail for causing a commotion in the courtroom. That is criminal contempt, and today, I'm talking about civil contempt. When a judge issues an order, and you are in violation of that order, you can be hauled into court by the judge to show cause why you should not be found in contempt. You must then explain why you should not be found in contempt, or the judge will hold you in contempt. A person in civil contempt may be subject to imprisonment. You can be locked up in jail if you do not follow the orders of a judge. You can be imprisoned for up to 90 days, but you can then be hauled back into court and locked up again for another 90 days if you have not done what the judge has ordered you to do. This process can go on, over and over, for up to a year. This cycle of imprisonment can make it very difficult, if not impossible, to fulfill your obligation of the order. And nobody wants to be in jail, so it is very important to follow the orders any judge gives to you. So how can you get rid of this contempt? You can be held in jail until the contempt no longer continues. So you can get out of jail by following the order of the judge that you were in violation of in the first place. For instance, if you have been found in civil contempt for not paying child support ordered by a judge, and thrown into jail, once you pay the amount that you have not paid, you will be released from jail and will no longer be in contempt. Also, in the order that imprisons you, the judge will specify steps that can be taken to purge the contempt. If you follow these steps, you will no longer be in contempt and you will be released from jail. For example, if you are in jail for violation of a child support order, the judge may say that you can purge the contempt by paying a certain amount of money at that time, and a certain amount of money on another date or another 2 dates, even if those payments do not cover the entire amount that you are behind. You can avoid jail altogether by making the payment in court that day, and you will be out of contempt once you make all the purge payments. Once you are out of jail, you must still follow the original order that you had violated, or you may find yourself in contempt all over again. There are 4 things that must be shown for you to be found in civil contempt. The first thing that must be shown is that the order is still in force. For example, if there is an alimony order or a child support order that still requires you to make payments, the order is still in force, and you may be found in contempt if you are in violation of the order. The second thing that must be shown is that the purpose of the order may still be served by compliance with the order. For instance, a child support order is to provide financial support for your child, a purpose that would still be served by making that payment after a violation of the order. The third, and the big thing that must be shown for you to be found in contempt, is that the violation must be willful. The violation must be voluntary and intentional. If the violation is not willful, then you cannot be found in civil contempt. The fourth thing that must be shown, which follows closely with the willful prong, is that you must have the ability to perform the obligation that was ordered. So, if you are ordered to pay alimony, but you have lost your job and you do not have the ability to make the payment through reasonable measures, such as getting another job, then you cannot be found in civil contempt. However, if you have lost your job and make no effort to find another job, even though there is job availability, then you would still have the ability to follow the order and could be found in contempt for violation of that order. How does this process unfold? The civil contempt process may be initiated by a motion by the aggrieved party to show cause as to why you should not be held in contempt. So, if you are under orders to pay alimony, but do not pay, your former spouse may file a show cause motion, which starts the civil contempt process. This motion must have a sworn statement of why you should be held in contempt. It must state, under oath, what it is that you have done that is in violation of a judge's orders, such as not making alimony or child support payments. The aggrieved party has the burden of proof to show that you are in willful violation of an order. If they show probable cause that you are in violation of an order, the judge will issue a show cause order, ordering you to come into court to explain why you should not be found in contempt. You will then have the burden of proof to show that you are not in contempt, such as by showing the contempt is not willful. So, if you want to stay out of jail, you must abide by every order a judge issues that orders you to take some kind of action, or you may find yourself in contempt for violation of a judge's order. If you do find yourself being hauled into court on a show cause order, it would be a good idea to find legal representation to help you in that situation. And the East Carolina Law Group is here to help you through this and many other legal situations you may find yourself in.
So thank you for tuning into the East Carolina Law Group Self-Help Series. We hope that you found these videos informative and have been informational in helping you determine what your next course of action should be in your own particular situation. If you find yourself needing additional legal help, we're available, and you can set up a consultation by calling our office at 252-453-2273. That's 252-453-2273. Or you can look us up on our website at eastcarolinalaw.com, or you can find us on Facebook at the East Carolina Law Group, and we post regularly on there, sometimes almost daily. We put everything from new legal information to office closures and things of that nature, and we provide updates on things that are happening in North Carolina and in our local district. So once again, if you need to get in touch with us, it's 252-453-2273. The East Carolina Law Group, where your family is our priority.